First of all, I just want to say thank you to the Federalist Society and, of course, to Leotis for putting this on again this year. I'm Jan Crawford, and I cover the court for CBS News, and I've been covering the Supreme Court since 1994. So as a Supreme Court reporter, there are a lot of panels that preview the upcoming cases, of course, this time of year, every year. And I think what the Federalist Society has been doing in the last few years, and particularly with Lee's involvement, has really been illuminating, and I think the panel that they've assembled this year, the moderator excluded, is really the best possible people that you could have weighing in on what are a number of really interesting cases the court has already decided to take on this term, and then also some kind of look forwards to cases that are brewing out there that we expect or hope that the justices will take up this term. So my job as moderator is to try to basically make sure that I can pronounce all their names when I'm introducing them to you, and I'm just going to try to stay out of the way because we'd like to be able to have some time for questions from you guys. So what we're going to do is each of our panelists have divided up the cases that are the most interesting so far, and they're going to present them for about 10 minutes, and we're going to keep on our time because I didn't bring the hook. And then after they give their presentation, we're going to open it up here on the panel for 5 minutes or so after each one's done, just to kind of react. And then after they're all done, we're going to turn it over to questions. That makes sense? Yeah, okay. Now, see, I'm not explaining the cases, probably a good thing. I'm going to introduce them all first, and then we're going to obviously kind of go in order just to make it simplest. So we're going to start with Tom. Most of you guys, I'm sure, particularly if you cover the court or are familiar with the court, know Tom Hungar. He's a partner at Gibson Dunn. He's co-chairs the firm Appellate and Constitutional Law Practice Group. You guys all at firms have different ways of putting that. But Tom was the Deputy U.S. Solicitor General from 2003 to 2008. There, he focused on business-related issues like antitrust, bankruptcy, securities, intellectual property. He has argued 25 cases before the Supreme Court and clerked for Justice Kennedy. And next to Tom is Adam Mossoff. See, I'm getting the names. Adam Mossoff, whose name, of course, we see a lot, not in papers and different things that he's written. Adam is a professor at George Mason. He focuses on property and intellectual property, especially has done some really interesting work on the history of patents. So he's going to have kind of a lot to say today on some of these cases. He's also taught cyber law and trust and estates. And I've got to say this, at the University of Chicago, where he went to law school, he was, in showing that Adam can weather any storm, was a research assistant for Richard Epstein. So, and he also clerked for Judge Weiner on the Fifth Circuit. And then after Adam, we're going to go to Elizabeth Papez. Yes? Yeah. Okay. Who's a partner at Winston & Strawn's, and they're in their appellate practice. She formerly served as the Deputy Assistant Attorney General, also in the Office of Legal Counsel. She's got extensive experience in complex business and compliance issues. She's briefed everyone from members of Congress to advising people in the executive branch on a range of statutory and business issues, and she clerked on the Supreme Court for Justice Thomas. Mark Rienzi is, of course, we're going to bring these guys into down at the other end of the table. Mark's a professor at Catholic University's Columbus School of Law. He teaches evidence and torts. He previously was in the litigation practice of Wilmer Hill, where he focused on intellectual property and First Amendment issues. And he's done quite a number of cases, successfully represented plaintiffs in cases involving First Amendment claims and rights of conscience. In fact, some recent cases on that, and clerk for Judge Williams here on the D.C. Circuit. Next to Mark is the old cliche, the guy who really needs no introduction in this room. I would say legendary, Mike Carvin, but we got to introduce him anyway just for administrative purposes. So Mike is a partner at Jones Day, where, of course, we all know he focuses on constitutional, appellate, civil rights, civil litigation. You may not realize this, but of course, before entering private practice, Mike was Deputy Assistant Attorney General, also in the Office of Legal Counsel, and he was also a Deputy AG in the Civil Rights Division. You do know Mike has argued numerous cases before the Supreme Court. The really boring ones, that's the ones that Mike Carvin takes on, you know, things like tobacco litigation, redistricting, the census, racial preferences, Florida recount involving George Bush back in 2000 in the Florida Supreme Court. So Mike's got to kind of practice it. If you're a reporter, you're calling Mike Carvin a lot. And he, of course, keeping true to form, is now counsel in the healthcare reform cases, representing the NFIB down in that 11th Circuit case that, as we saw yesterday, appears headed straight to the Supreme Court pretty quickly. And then next to Mike is another guy who needs no introduction to, Neil Katyal, who you also are very familiar with, having seen him at the court a lot recently. Neil's got some news. He recently joined Hogan Lovells as a partner, also in the, of course, appellate practice. Neil, as again, you know, here in this very informed crowd, was previously the Deputy Solicitor General, acting Solicitor General when Justice Kagan went up to the Supreme Court, obviously an expert in constitutional law, executive power issues. He's had a number of high-profile cases. I think what you probably best know Neil for, though, is his victory in Hamdan versus Rumsfeld. And that, of course, is where the Supreme Court ruled that President Bush's system of military tribunals down at Guantanamo Bay violated the Constitution. Neil clerked for Judge Breyer on the Supreme Court. So that's our very esteemed panel. See, I told you guys that we are very fortunate to hear. So I'm just going to start turning it over to Tom. Tom is going to, and again, they've divided the cases. Tom's going to talk about U.S. versus Jones and Sackett versus EPA. 10 minutes, and then we're going to have a lightning round of panel reaction for 5. Okay? Mr. Hungar.
Thanks very much, Jan. Thank you all for being here, and thank you to the Federalist Society and to Lee for inviting me to participate. And I'm very honored, especially after hearing those introductions, to be included in this esteemed panel. I actually have a slightly different list than Jan's because in addition to those 2 cases, I'm going to also talk a little bit about the Arizona immigration case, although that's not actually on the court's merits docket quite yet and may or may not be down the road. Anyway, first turning to U.S. against Jones, that's the Fourth Amendment GPS tracking case. In this case, the D.C. police and FBI were investigating Mr. Jones for cocaine trafficking. They installed a GPS device after obtaining a warrant. The warrant said they could install the GPS device on his Jeep Cherokee within 10 days in D.C. Naturally, on the 11th day, they installed the GPS tracking device on his Jeep Cherokee in Maryland. Sort of like the beginnings of a law school issue spotting exam. After conducting the GPS surveillance for a month, they arrested him, tried him, and convicted him, and he appealed, and the D.C. Circuit, in an opinion by Judge Ginsburg, held that the warrantless search tracking through the GPS device violated the 14th Amendment under what has come to be called the mosaic theory. That is, the long-term prolonged surveillance provides a mosaic of information about an individual's whereabouts and travels that is more than any given individual watching them could possibly collect, because it's 24 hours a day, 7 days a week. And this is more intrusive than a shorter-term or more traditional form of surveillance and violates the reasonable expectations of privacy of the individual. And then NBank was denied by a 5-4 vote. The government's cert petition asked the court to grant cert to decide whether the police can use GPS devices for surveillance without a warrant. And the court granted on that question, but also added a second question, which asks whether the installation of the device was itself a violation of the Fourth Amendment as an unreasonable search or seizure in the absence of a warrant. The addition of that second question may prove to be very significant because there is a 1983 Supreme Court case called the Knox case, in which the court held that the use of a radio beeper to track the travels of a car across the wilds of Minnesota to a drug hideout was constitutional because, in essence, what the court said is a person traveling in an automobile on public thoroughfares has no reasonable expectation of privacy in his movements from one place to another, even though obviously the technology made it easier to track. It didn't provide information that couldn't have been obtained by someone in the public who happened to be watching, and therefore there was no problem. The court dropped a footnote, though, in the Knox case, noting that it hadn't been called upon to decide whether the planting of the device itself was problematic under the Fourth Amendment. Now they have added this question to decide that question. I think, given Knox, and notwithstanding the D.C. Circuit's reasoning, it's unlikely that the court will hold that the actual surveillance is unconstitutional, because what is being surveyed is in fact in the public domain, if you will. I think the tougher question for the government is going to be the one that the court added, because you can certainly see some Fourth Amendment concerns implicated when the police, without consent, install government tracking devices on private property, which is certainly, arguably at least, a non-trivial interference with the property rights of the car owner. So I would say stay tuned to this one, and in particular watch how some of the more conservative or less liberal, depending on your perspective, justices like Justice Scalia react to the government's position on this question, see whether the property rights concerns overwhelm the law enforcement interests. So that's a quick commentary on the Jones case. The Arizona against the United States case, of course.
That was a 4-minute commentary.
All right, I'll speed it up. The Arizona against the United States case, of course, is the big immigration case out of the Ninth Circuit, and the court will not consider that. Well, the government's brief in opposition is due in October right now, and they tend to get multiple extensions, and so far they've only had one, so we may not hear from the court on that until December or January. And as I'm sure you know, that's kind of a follow-on to the Arizona immigration case they had last year, with additional Arizona statutory provisions essentially requiring state law enforcement and local law enforcement officials in Arizona to provide additional assistance to federal government enforcement efforts under the immigration laws. Somewhat contrary to usual form in the area of preemption, the Obama administration filed suit against the state to enjoin enforcement of the law, and succeeded in enjoining several provisions in the district court and Ninth Circuit. And of course, the petition is now pending. I think, given the importance of the issue, the petition somewhat cutely notes that the government thought the case was so important that they sent their senior deputy solicitor general to argue the preliminary injunction motion in the district court, not something you see every day. And the fact that this is coming up in other states, the fact that obviously immigration is a hugely important issue. The court just today took 2 immigration cases, I think, although not of the same apparent importance as this one. And the fact that the Ninth Circuit's decision is frankly difficult to square with the Supreme Court's decision in the Chamber of Commerce case last term, and also, in some respects at least, with the statute. Judge Bea's dissent is worth, in the Ninth Circuit, is worth reading. He equates the majority opinion with Humpty Dumpty in their use of in their interpretation of language, I should say. In any event, my guess is that the court is likely to take it. Whether they will GVR, grant, vacate, and remand in light of the Chamber of Commerce case, which was decided after the Ninth Circuit, or instead take the case on the merits, is a tough question. But I lean in favor of a merits decision in that case this term. And I think if they do take it on the merits, they're likely to reverse, at least in part. Then turning to the Sackett case in a completely different area of the law. This is the Clean Water Act case. Mr. and Mrs. Sackett own a half-acre plot of land in Idaho where they planned to build their dream house. but after they had graded the land, their dream turned into a nightmare when they received an administrative compliance order from the EPA instructing them to return the land to its natural habitat condition because the EPA had determined without a hearing that it was a wetland, and if they didn't comply, they would be subjected to up to $37,500 a day in sanctions, which I think they note in their petition as something like $40 million of potential sanctions at this point because it's been going on so long. They filed suit seeking a determination of whether, in fact, their land was jurisdictional wetlands subject to the Clean Water Act. The District Court and the Ninth Circuit, like every other federal court to consider the question, said there's no pre-enforcement judicial review of EPA administrative compliance orders. And this is an issue that affects not just the Clean Water Act, but it comes up under the Clean Air Act, under CERCLA, the Safe Drinking Water Act. It's a pretty common enforcement regime for the EPA. So the court's going to decide two questions. Number one, whether the Clean Water Act itself impliedly precludes a judicial review, or, and two, if it does, whether that violates the Due Process Clause. And the government, I think I've actually briefed this issue when I was at the government. The government has some substantial statutory interpretation arguments in favor of the conclusion that the Act does preclude judicial review, but they're not slam dunks, and you could certainly see the justices, again, the more property rights concerned justices in particular, reaching the conclusion that the statute is not clear. There is a presumption in favor of judicial review, and particularly where you have a substantial constitutional due process question, as is raised here by the incredibly onerous burdens placed on landowners in this position where, as a practical matter, to litigate is to risk bankruptcy. They may conclude that to avoid the difficult constitutional question that would be presented if there is no opportunity for judicial review, the safest way out is to construe the statute to permit it.
All right, thank you.
How'd I do?
All right, so you stuck to 10 minutes.
Excellent.
And a very enlightening and summary, guys, so let's, okay, so now we're going to allow the panel to react to some of that. Anybody want to weigh in first? Obviously, we heard that Tom expects the immigration case to reach a merits decision this term. But what else jumps out at any of you guys? Just weigh in on our Neil down there at the end.
Tom, on the GPS case, and here I'm a little biased. I wrote the cert petition, so so let's be. So I just want to disclose that. I agree with you that the first question about whether or not the Fourth Amendment was violated by the aggregation of this data is one that's likely to be in favor of the government, just because these are all things in plain view, and even adding them all up, 0 + 0 + 0 still equals 0. But you suggest that the property rights argument, which was fleshed out in a really interesting opinion below by Judge Kavanaugh, a really interesting thinker on the bench, is something that will give the government some trouble. Don't you see that as a pretty minimal intrusion on a person's property rights? I mean, the government chalks cars all the time. I mean, traffic police and so on. If this theory of intrusion is right, I think it would call into question just lots of standard government practices.
Yeah, I mean, it really just depends on how the court chooses to just define the intrusion. And on the one hand, you can say it's trivial. They stuck a little device on the underside of a car. Nobody saw it. Nobody knew it was there. It didn't affect the operation of the car. It didn't prevent them from doing anything they would have done. It didn't damage the car in any way. It didn't draw power from the car. It just had no impact. On the other hand, you could say the idea that someone is using my car as transforming my own vehicle, which I use for my own transportation, into a vehicle for transporting a device used to monitor my whereabouts at every moment of the day and night, is about as significant an intrusion on my personal autonomy and the use of my vehicle as you can imagine. Now, I mean, my guess is the government probably gets the better of that argument, but I
just because there's that fuzziness when you say personal autonomy, what you're really saying again is privacy is violated.
Right.
It's not really a property right; it's a privacy right.
Right.
All right. Thanks. All right. So, Tom, you've set a very high bar in insight and time keeping here. So, Professor, we're going to go next to Professor Masaf. You were going to talk about two cases, Mayo Collaborative Services versus Prometheus Labs, and Golan.
Yes, thank you. And yeah, Tom has set a very high bar for me, especially since I'll be talking about intellectual property cases. So unless you're a tech geek or a sci-fi geek, you can kind of just check out and come back in when Elizabeth was ready to speak. As Jen said, I'm going to be speaking on two of the intellectual property cases that'll be heard by the Supreme Court this term, Mayo v. Prometheus, which is a patent case. And the issue is whether a method for correlating administered drugs to a patient, correlating the administration of the drugs with the success rate within the body of the patient, is a patentable invention or not. So the question is this something that counts as an invention, or is this merely just discovery of facts? And are they really trying to claim as property natural phenomena in the world which are not patentable under the patent laws? And then Golan, which I'll just be offering a quick comment on because Neil Katyal will be probably speaking more on that. That's a copyright case, and that issue is whether that case raises the issue of whether Congress can retroactively renew foreign works that have fallen into the public domain, or whether doing so violates either the First Amendment or the Copyright and Patent Clause in Article 1, Section 8, Clause 8, which authorizes Congress to pass the copyright and patent laws. Now, interesting enough, both of these cases are sequels or consequences of cases that had made it to the Supreme Court in prior years. Mayo really follows upon two prior cases. The first was a case called LabCorp v. Metabolite, which the court granted cert in the October 2005 term. And then it was digged. It was dismissed for being improvidently granted in the spring of 2006. In fact, LabCorp raised almost the exact same issue that's raised in Mayo. LabCorp raised the issue of whether a method of correlating hormone levels in a body is a patentable method, or is this really just observation of facts in the world. And also, it also follows upon another patent case that was just decided last year, Bilski v. Kapos. And in fact, following Bilski, the court did a GVR. It granted, vacated, and remanded back to the Federal Circuit its Mayo decision. And then on remand, the Federal Circuit just basically reissued almost the exact same opinion. It came to the exact same result with almost the exact same reasoning, almost a kind of a thumbing its nose at the U.S. Supreme Court. So it wasn't much of a surprise that the U.S. Supreme Court granted cert when it came back when the cert petition was filed again. And then Golan really follows a decision from 2003, Eldred v. Ashcroft. Eldred involved a challenge to the Copyright Term Extension Act and whether Congress could retroactively extend copyright terms. And Eldred represented really a stinging loss for a movement of academics who have been seeking to limit the expansion of copyright protections, because the court upheld the Copyright Term Extension Act as a legitimate exercise of Congress's authority under the Copyright and Patent Clause. But the court, in deciding that case, inspired the challenge that led to Golan, because they explained in that case that challenges to congressional copyright statutes might work if the laws contradict the, quote, traditional contours, unquote, of copyright protections that have historically been afforded. So basically, you could summarize the theme of both of these cases, Mayo and Golan, as if at first you don't succeed, try again. So I'll spend most of my time on Mayo, and then I'll just briefly comment on Golan. All right, as I said, Mayo arises from really rises from the expansion in patentable inventions on medical products and methods that has occurred since the biotech revolution began approximately 30 years ago. Prometheus is the owner of 2 patents on methods for providing drug treatments to patients who are suffering from inflammatory bowel disease. Very exciting stuff. In fact, the technical details of patents, and I readily admit even the technical details of patent law, have been known to be the cure for insomnia. So I'm not going to go into those. I'm just going to summarize the relevant invention. And here's the invention. Essentially, the patents cover 3 steps. First, administer a drug to a subject. Second, determine the level of the drug in the subject. And then third, decide whether the next dose should be same, higher, or lower. That's essentially the invention. And this does have some benefits. It minimizes the toxic side effects of the drugs that are being provided, and therefore increases the benefits of the therapeutic treatment. The issue, thus, is whether this is an invention deserving of protection under the patent laws. What in patent law we call patentable subject matter. Does this fall within the scope of protection that the patent laws say can be patented as inventions or discoveries? Or is this merely a discovery of facts of the world and therefore not patentable, since facts of the world are not inventions? Now, the trial court agreed with the Mayo Clinic and said this is in fact invalid. These patents are invalid. These are not inventions. They cover natural phenomena. There's correlations between chemicals in the body. They're natural phenomena. There's no inventive act here. And so this runs afoul of the fundamental rule in patent law that you can only patent truly inventions or discoveries. You can't patent laws of nature, natural phenomena, or abstract ideas. The Federal Circuit reversed the trial court and said, no, Prometheus patents actually do cover inventions. They said this treatment method is not a natural phenomenon. It involves human intervention in the body with human chemicals that are introduced into the human body by another human. And so you are transforming the human body, and this is a method of transforming the human body. And these types of methods have been patented since the foundations of the patent system going back to 1790 with the first Patent Act. As I said, the Supreme Court GVR'd in light of the Bilski decision last year because Bilski, Supreme Court, it wasn't on biotech, it was on business methods and whether business methods are patentable. In Bilski, the court said business methods are patentable, but the test that the Federal Circuit's been using is not a legitimate test. And so it threw out the legal test that the Federal Circuit had been using. It used that same test in the Mayo case, which is why it GVR'd it, and they basically just reused the same test. And so it'll be interesting to see what happens. All right, what will happen here? Well, there's a lot of ferment in patent law in recent years. Many of you may have known that the government actually just enacted a massive overhaul of the entire patent system just this month, the biggest overhaul since 1952. And the Supreme Court itself has re-engaged with the details of the patent system to a degree not seen since the mid-19th century. Since 2006, the Supreme Court has heard at least 10 cases, or granted cert in at least 10 cases in patent law. It issued 9 opinions with one strong dissent from the Dig and LabCorp by Justice Breyer. And the Federal Circuit has lost a lot of these cases, although last year it saw a slight reversal of fortunes for it. If you're a betting person, past practice is just to bet against the Federal Circuit. And as I said, this case really addresses the issue of the expansion in patentable subject matter following the biotech revolution. Are these kind of new discoveries in administering drugs, the way that we can manipulate chemicals in the body through methods and different products, are these actually patentable discoveries? And the biggest concern in these cases is that the court is very much aware that it does not want to formulate a rule that will inadvertently prevent the next wave of innovation from receiving patent protection. That's the biggest concern here, that they're going to say, this is not a patentable invention because of X, and then X will lead to the unintended result of foreclosing the patent system completely to entire categories of discoveries, inventions that we can't foresee because this is what innovation is all about. We don't know what's going to be the next great innovation around the corner. And this is, of course, what the biotech industry is arguing in this case, is that you threaten the entire biotech industry and everything that has come about from the biotech industry in the past 20 or 30 years with all the treatments and everything because you do not know what the next great biotech invention will be. So in these cases, a lot rides on 2 of the approaches that justices take, or that courts generally take in these type of patentable subject matter cases. They sometimes adopt basically what I call a categorical approach. They could basically say, well, this patent covers a natural phenomenon, or this patent covers an abstract idea, and therefore it's not patentable. They basically say this is tantamount to patenting, say, E equals MC squared, or this is tantamount to patenting just a tree in the world, or something of that sort, and this is not an invention. This is not what it's meant by an invention. The problem with this is that it tends to be somewhat conclusory. There's not a lot of reasoning behind that when you see the courts engage in that type of reasoning. And in fact, this is exactly what you saw in Bilski. In Bilski, the court said, well, business methods are okay, but this business method's abstract. It's an abstract idea and it's not patentable. Why? Because it's abstract. It's not patentable. And so there's something unsatisfying with this approach. So the alternative approach that is often adopted now is judges and justices adopt more of a functionalist approach. And they ask the question of what undermines innovation more, and which carries the higher risk of undermining the progress in the useful arts in terms of what we grant patents to. And in fact, this was the approach adopted by Justice Breyer in his very strongly worded dissent from the Dig and the LabCorp decision from 2006. He argued in that case that you have lots of low-quality patents here patents are issuing for things that really aren't true inventions, that are not innovative. He also said that when you have patents on basic tools of scientific research, that this undermines the future innovation and commercialization in the marketplace of the follow-on downstream medical products that come from that research. And so when you patent correlations and other types of things that scientists observe, that this really undermines actual further innovation. And that when you have too many patents, even if these are valid, that this increases licensing costs, which also leads to undermining innovation and raises lots of problems. So in terms of pre-gaming, well, interestingly enough, we're not looking into a crystal ball here in knowing exactly how the court might rule, because we already have on record Justice Breyer saying these are invalid patents. And Justice Breyer was joined in his dissent by Justice Stevens and Justice Souter. So we actually know, at a minimum, there are two justices on the court who are already going to vote against Prometheus and say this is an invalid patent. Now, Justice Stevens is not around anymore, but Justice Sotomayor, who had replaced him, she will probably join with Justice Breyer and Justice Stevens, because she joined with Justice Stevens in the Bilski case when he wrote a concurrence saying, yes, we should reverse the Federal Circuit here, but we should go even further and say there shouldn't be any business method patents at all, for the exact same reasons that Justice Breyer identified against the treatment patents for medical treatment methods. So at a minimum, if the court ends up upholding this patent as a patentable method for treating diseases, it's going to be a split decision with at least 2 or 3 justices writing a dissent. In the Golan case, as I said, this is a challenge to retroactive renewal of copyright, the terms copyrights of works that had fallen into the public domain. Foreign works, this was a statute that was enacted pursuant to our treaty obligations under TRIPS. And as I mentioned, this case has been driven mostly by an academic movement that led to litigation in Eldred. And this movement, they're sometimes referred to as copyright minimalists. Also, they sometimes go by the name the copy left. And as I said, these plaintiffs have taken their cue from the loss in Eldred, which said that Congress has substantial leeway to define the scope of copyright protections as long as it doesn't violate or contradict the traditional contours of copyright protections provided in past statutes. Well, this is exactly the argument that the plaintiffs have made. As the 10th Circuit opinion observed, quote, plaintiffs have cast their facial challenge to the statute in terms of, quote, the First Amendment, the contours of which may be informed by the copyright clause, end quote. And now the trial court then agreed that this retroactive renewal of copyright terms of works that had fallen in the public domain was in fact unconstitutional. The 10th Circuit reversed. Now, my observation is from the patent side, and that is that if the court does end up taking historical practices seriously, then I predict that it's unlikely the plaintiffs will win in this case. And that is because in my research of the early years of the American Republic, at least with respect to patents, there were a substantial number of renewal of patents, patents that had fallen into the public domain. There were lots of patents, both through individual acts of Congress and under the 1836 Patent Act, where patents had actually, their terms had ended, the patentees had appealed for an extension of their terms, and they were granted. And these patents were repeatedly litigated and challenged as being invalid. And the Supreme Court and lower federal courts at the time repeatedly upheld not only the patents, but the act of renewing them as valid. Thus, if copyright and patent term extensions, even for works that had fallen into the public domain, seems to be consistent with the traditional contours of the copyright and patent clause of the Constitution. At least this is the question that we should be asking, because to say traditional contours means we should be looking to history. We should be looking to what are the traditional practices, and thus I think the court should be taking seriously these historical practices, at least if they take seriously this point that they made in Eldred, that they're going to look to such matters as traditional contours. But even as a prudential matter, setting aside the historical practices, if the court accepts the plaintiff's arguments here, then this is going to raise a lot of problems, because it's going to call into question a substantial amount of case law relating to copyright protections of works on digital content and on the internet. In fact, the court, for instance, would be required to then revisit a very similar challenge raised in Golan that was made to the Digital Millennium Copyright Act that was rejected by the Second Circuit back in 2001 on the exact same grounds, with the exact same reasoning that the 10th Circuit rejected the Golan, the argument made by Golan in this case. So, so not only does the plaintiff's arguments seem to contradict historical practices, it raises a lot of prudential concerns about the status of copyright protections in our new digital era. So thank you.
Thank you very much, Professor. And I can see why you're a very popular professor, because that was really interesting, even though you said we were all falling asleep. So no, not at all. So Neil was going to respond on Golan. You were kind of tagged to do that. But if anyone else wants to weigh in too. But one of the questions I was hoping you might could say is obviously when we hear this summary, not only is this a highly technical subject matter, the court has had quite a number of these cases, and at some point they, you start thinking, are they just all running together? And of course the patent bar always says, oh no, the sky's falling if the court makes this horrible ruling and no one will invent anything anymore. So I was wondering, how significant are these cases? Mm-hmm. And what impact, what practical impact could either of these cases have? Neil, do you want to just...
Sure. I do think that there's a potential for the Mayo Clinic case to be important. I don't think it's the entire future of the biotech industry or anything that the, kind of doomsayers are saying. But I do think that there's a very deep question that the court has been dancing around for some years, and some of us thought the court was going to get into it in the Bilski case a few years ago, which is, what are the limits of the patent system? Can you patent anything? The Supreme Court has said, no, you can't patent something that is a product of nature, or E equals MC squared. But what does that general guidance tell us in the specific area of the biotech industry? The Mayo case is a potential set of first questions that the court might get into. Later in the term, the court may be asked to hear the myriad genetics case. Can you patent aspects of the human genome? And that, again, that raises those foundational questions. Can you patent things that just literally exist in nature and not? With respect to the Golan case, I actually don't disagree at all with what Professor Mossoff said. Here, the basic issue, it sounds very technical, but the basic issue is this. You've got all of these works that are in the public domain. That means that they're not copyrighted, that anyone can use. And here, there are all sorts of artists and composers and other things that are using them, like Shostakovich compositions and the like. And then Congress comes along and says, oh, well, pursuant to these treaties we've negotiated, we're now going to yank that work out of the public domain and put it back into the copyright system. And the question is whether Congress can do that or not. And here again, just by way of disclosure, I wrote the brief in opposition saying that Congress could do that. And the reason for it is that Congress, and this I think dovetails with what Professor Mossoff was saying, is Congress has done that from the very start. In 1790, the very first Patent Act took works that were in the public domain, and the first Copyright Act put works in the public domain and then copyrighted them and made them subject to certain protections, and they've done that since. And so if the ball game is kind of the traditional one, what has Congress done in the past? I think there's a very good argument that what Congress has done here is permissible.
You, Professor, you agree?
Yes, on both accounts. Although the Mr. Collier is exactly right. There's this another case, Myriad, which is about whether genes can be patented or not. That's currently working its way through the system, and it's at the federal circuit right now. And the Supreme Court will definitely has an eye on the Myriad, because in deciding the Mayo case, it could hand down a rule that would then force it to rule against gene patents in the Myriad case. And if you knock out both the gene patents and method patents in the biotech industry, then you're going to have a problem with the biotech industry. Then the biotech industry will have a certain legitimate ground to say the sky is now falling, because the gene patents have been extremely important for the biotech industry in the past 10 or 15 years in terms of getting investment and developing the type of treatment and cures that they've been able to develop in that time period.
All right, Professor, thanks very much. Now we're going to go to our next panelist, Elizabeth Papaz, who's got 3 cases that raise somewhat different but all quite potentially significant constitutional questions. Douglas versus SRM Hospital, Florence versus Board of Freeholders, and M.B.Z. versus Clinton. I don't know what order you want to take those in, but again, thank you.
Thanks so much, Jan, and thanks to Lee and the Society for the opportunity to be here. It's great and a lot of fun to be with such a good panel. As Jan mentioned, I'm talking about 3 cases today that on the surface seem quite unrelated. The first is a case about the constitutionality of certain jailhouse strip searches. That's the Florence case. The next is a case involving the court's ability to resolve a dispute between the executive branch and the Congress about whether a person born in Jerusalem is entitled to have their passport list Israel as the place of their birth. And the last is actually a cluster of cases, the Douglas cases, about whether Medicaid providers can obtain federal injunctions against state Medicaid cuts on the theory that they're preempted by federal law. And I say they're unrelated on the surface because I think there are a couple of commonalities that I'll touch on up front as maybe fodder for some future discussion. The first is all of the cases have a constitutional dimension, which is, I think, significant because a lot of the court's docket is purely statutory. But further, and perhaps more importantly, all 3 cases involve the role and power of the federal courts to step in and say when another part of the government has gone too far or overstepped its bounds as against individual rights. And I think that makes these cases, which are not themselves headliners on the order of, the healthcare mandate or the DOMA cases, interesting and important in their own right, but also very important to watch because how the court resolves the kind of separation of powers and federalism issues in the kind of cases I'm talking about today often informs how the court decides the blockbuster and headline cases that we're going to see in the healthcare arena, in DOMA, same issues, in whether it's a Boumediene versus Bush, has the executive branch gone too far? Or, whether it's the gun cases or prison overcrowding like we saw last term, has a state gone too far? All of these cases turn on a basic issue, which is when and under what circumstances can and will the federal court step in and say a branch of government has gone too far. And I guess, for the justices, it's interesting in their prior cases, if you take someone like Justice Kennedy, we have something like healthcare maybe coming down the pike. He's, been on the side of the court saying there's broad Article I power in cases like Comstock. Or Raich, on the other hand, he's been on the side of the court stepping in against the government in cases like prison overcrowding or Boumediene. So with that, I'll go to the cases with a focus on sort of those themes. I'll start with the Douglas cases, which are the Medicaid funding cases. They're sort of top of mind. They're teed up for argument the first Monday, October 3rd, so we'll see them shortly. They come out of the Ninth Circuit. It's actually a cluster of 7 decisions, 3 consolidated petitions. Basic issue is this. Medicaid is a cooperative federal-state venture, right? States fund it in part. They give healthcare providers some state money. Federal government gives them some federal money to provide services largely for indigent people. The California state government in 2008 and 2009 was facing a budget crisis, and so to address the budget shortfall, they tried to enact some budget cuts that would reduce by 1 to 10% some of the state reimbursements for certain types of healthcare providers, adult daycare centers, hospital services, and the like. The providers whose rates were cut went to federal court and said, please enter injunction against the state from implementing these cuts because the cuts that the state wants to make to our reimbursements are preempted by the Medicaid statute, a federal law that says, in relevant part, states have to have Medicaid plans that are consistent with efficiency, economy, quality of care, and that reimburse enough to attract providers. Court of Appeals, Ninth Circuit, agreed with the providers and enjoined the state of California from reducing state Medicaid reimbursements to these providers. And the issue in the headline in these cases at the Supreme Court is, where do the federal courts get the power to issue this injunction against the states? The reason it's a big issue here is that the Ninth Circuit and all of the players in the case agree that the federal statute in issue, the Medicaid statute, does not give providers a private right of action to go to federal court and enforce these pricing provisions or these reimbursement provisions. What the Ninth Circuit held is that that doesn't matter the providers have a cause of action directly under the U.S. Constitution and the Supremacy Clause to get an injunction against the state under the federal statute. That's a really big deal, I think, as everyone knows and has been writing about over the last decade or so in the Sandoval line of cases. The Supreme Court has been sort of ratcheting back and being very careful about when federal courts can imply private rights of action for private persons to enforce federal laws, particularly when there's an agency regulator like the SEC, or in this case, HHS, that has an enforcement role, and there's some uniformity that goes with that, and Congress made a choice to have the government versus private persons do the enforcing. So there's the Sandoval line of cases, even in the Bivens cases, where the court has recognized a cause of action directly under the Constitution. You know, in Huey versus Castaneda a couple of terms ago, the Supreme Court sort of was drawing lines. So really interesting case for the Supreme Court, you know, and really actually a formidable lineup on either side of the case, I should note. The states, the state of California and other states, and the Solicitor General are saying reverse the Ninth Circuit. Do not allow a private cause of action directly under the Supremacy Clause. One thing to watch, I'd note, is the states are saying Supremacy Clause confers no substantive rights. The SG's office threads the needle a little bit. I don't know how much Neil can talk about this, but they thread the needle a little bit more and say, in this case, hold that there's no cause of action in reverse. But let's not close the door on maybe other areas where we might want to see a cause of action directly under the Constitution. On the other side, for the respondents, is the Ninth Circuit, obviously, the Chamber of Commerce, and members of Congress who are saying, no, you should let private persons and providers come in and enforce. HHS takes too long. It's inefficient. You know, and what they've done smartly, frankly, is try to fit this case into a long line of precedents, starting back with Ex parte Young, saying, you know, the Supreme Court's long recognized that federal courts can enter injunctions, not give money, but enter injunctions against states for overstepping their bounds under a federal law. And even though the court's never been quite clear about what the source of the cause of action is there, the Supremacy Clause is clearly at play. Let us go. Important issue to business, obviously, because if you don't allow these private, or if you allow these private suits, there's going to be, you know, mayhem. The states are going to be subjected to a multiplicity of suits. No one's going to know whether a state scheme is fine or not. And actually, interestingly, I should point out, one thing that jumped out at me, and then I'll move to the next case, is in the brief for the members of Congress, on the side of the respondents, saying these suits should be allowed to go forward. One thing that struck me as really interesting, and this wasn't really developed in the briefs, but it's an important question, I think. The members of Congress brief is saying, let these suits go forward. Let providers come into federal court and get injunctions. But then they also say, and by the way, though, HHS in the next year is going to do a rulemaking and come up with an authoritative interpretation of this Medicare provision that, as I mentioned, says state plans have to be economic and efficient and attract providers. So what the brief seems to be saying is federal courts should jump in, enter the injunctions, not wait for the executive branch or HHS, and maybe say that this state reduction of 1 to 10% violates the federal statute. But then maybe what happens next year if HHS decides to flex its muscles and come in and say, actually, all the statute says is efficiency and economy. We're an agency. We're going to interpret that to mean that 1 to 10% reductions are A-OK. Did the court waste their time? Who wins? It implicates sort of an interesting line of Chevron cases and some more separation of powers issues. So I think it'll be interesting to see how that plays out at the argument. The Florence case is the strip search case. Long story short, it's coming out of the Third Circuit. The facts of the case are frankly unusual and a bit egregious, but the rule that the petitioners are asking for is actually fairly broad. Case arose out of a gentleman who had an outstanding and it turned out erroneous arrest warrant against him. He was driving with his family to a family event, gets pulled over. The officer runs his driver's license, finds out that he has an outstanding warrant. He gets arrested, placed in a New Jersey jail, and is subjected to repeated, visual intrusive strip searches. And this is on a minor offense. Meaning minor, maximum, I think, imprisonment time on this was like 6 months in prison. And it turns out in his case, the warrant was invalid. He shouldn't have been detained at all. So he went to district court, actually on behalf of a class that the district court certified. So it's a class action, a Fourth Amendment class action, which is sort of interesting, and said, look, it is just unreasonable and unconstitutional to subject people who are arrested on my sort of minor offense, a traffic violation, to strip searches without suspicion that we've actually got contraband on our body or something. So the issue in the case is basically, it's a Fourth Amendment issue. What sort of Fourth Amendment interests and expectations of privacy does a person have when they enter custody? And on the government side, how much should the courts, and this is a separation of powers issue, how much should the courts defer to the executive branch, whether it's a state government or the federal government, the SG, is on the side of the state here and saying, look, we have an interest in keeping our prisons safe. Prisoners, smuggle contraband in, they're dangerous, they might have diseases or other conditions. We need to be able to do these visual strip inspections to make sure everybody's safe. Defer to our interest. So the big fight in the Supreme Court is, as a threshold matter, do people who are arrested and put in a jail have a protected Fourth Amendment interest in not being strip searched? And interestingly, the states say they don't have any interest at all. The SG, again, a little more careful, said there is an interest, but it's reduced because being in jail is not like being in your house or being in a hotel room and you're under surveillance all the time for your own safety. And then the other issue for the court is when the government tells the courts that they need to do this sort of thing in order to keep a prison facility safe, how much deference does the government get? So the issue here is, again, federalism, separation of powers. And there's some interesting sort of legal doctrines that come into play, and we'll be interesting to see what the court does with that. The last case, but certainly not the least, is another big case which is of great interest to former OLC nerds like me. It's a big separation of powers case. Rare for the court to take because it's in the foreign policy arena. It's a case, the one I mentioned about passports, and it's a suit against the Secretary of State Clinton, and the basic issue is this. In 2002, the U.S. Congress passed a statute that said a person who is born in Jerusalem and is a United States citizen may request that the State Department list Jerusalem, Israel as the place of birth on their U.S. passport. Now, this was an issue for the executive branch, including in 2002. President Bush issued a signing statement, another area where the court, I don't know if they're going to engage that issue or not, said, look, I'm going to sign the bill, but you can't tell the executive branch to recognize a foreign state. The president, the executive branch, has a prerogative to do diplomatic recognition. We want to stay out of the fray on whether Jerusalem is Israeli or not, because that is a hot-button issue that needs to be resolved diplomatically, and we don't want to look like the U.S. is putting a thumb on the scale of that issue by putting out passports, which are statements essentially to foreign countries that the U.S. believes Jerusalem is part of Israel. So the executive branch said, we're not going to do that. The statute says if a person so requests, the Secretary of State must do it. Here, the petitioner, who's a little boy, 9 years old now, his parents petitioned the Secretary to list Jerusalem, Israel on his passport. The Secretary of State listed Jerusalem, period, did not put Israel. So the family sued and asked a federal court to order the Secretary of State to list Israel on the passport. Interesting case comes up through the D.C. Circuit, no split. The D.C. Circuit panel said, you know what, this is a political question. It's committed. It's the sort of thing that's committed to sort of the value judgments and political discretion of the political branches. We're not going to decide it. Interestingly, there was a motion for en banc rehearing in the D.C. Circuit. 3 judges, Judges Kavanaugh, Ginsburg, and I think Rogers dissented. They would have taken it en banc. Judge Edwards, who's senior and didn't get to vote in the en banc, issued a statement. He said, this is ridiculous. This is a big punt. This is not a political question. What's going on here is all the Congress and all that these people are asking us to do is say, where does the Constitution draw the line? Executive branch says they have a prerogative here not to do what the statute tells them to do, and they're saying it's a constitutional prerogative of theirs that they get to exercise. Well, we're the courts. We get to say what the law is. Why shouldn't we decide whether this sort of passport issue implicates an executive branch constitutional prerogatives, and if so, how does it stack up against Congress's powers in foreign affairs? And that's the issue before the court, and I would note it's an interesting case. Court does not often get into this area because foreign affairs is one of those fewer areas that's committed by the Constitution to both the legislature and the executive. Typically, when they get together, they're at the apex of their power, in the Supreme Court's words. When they disagree, it gets very messy. And in this case, though, what's interesting is the Supreme Court, took this case over the Solicitor General's objection. The Solicitor General said, don't take this case. And I don't envy the SG's office, and I think the folks on the panel can speak to this, because they have to defend the constitutionality and the validity of federal statutes, but also represent their client in the executive branch. And here, those two interests are opposed. The other thing is the court added a question. They added a merits question. They said, we'll talk about this political question thing and see whether we get to decide this or should decide this. And the other thing they popped in on the merits is, what's the nature of the constitutional issue here? Does the president have a power? And if so, is it being infringed by the Congress? So it'll be interesting to watch and interesting to see if this is going to be Marbury-like.
Thanks very much. On that case, let me just ask you before we go on to Professor Renzi, why do you think the court took it, and where do you think your old boss is going to come down? Obviously, remember Ms. Pepez, clerk for Justice Thomas.
I don't know if I want to quarterback where the boss is going to come out. I think I can say, I don't know why they took it. I think they're certainly interested in maybe exploring, consistent with where they've been on this. I think we saw this in the SOX Accounting Board case. Like Marbury, in the Accounting Board case, maybe in this case, the court is interested, it seems to me, in weighing in on what is its role vis-a-vis the other branches. That's very important when, as now, the same party, and this is on either side, has both political branches. So it could be that this ends with a whimper, like the Accounting Board case, in the sense that they say, well, we're not going to really do much here, except reaffirm that we get to say where these constitutional lines are drawn. So it could be something as sort of institutional as that. I don't know.
All right. Thanks very, very much. Very interesting. And you tied them all together. They stand on their own, but on nice themes too. So thank you.
We'll see if people let me hang on to that. I don't know.
Well, we'll see. We'll know next June. All right. Professor Renze's got two, again, interesting cases here, kind of looking at some free speech issues. Hosanna-Tabor Church versus EEOC and Knox versus SEIU.
Great. Thank
Professor
you.
Renze, thanks.
Yeah, as Jan said, there are two First Amendment cases. The first one's actually a religious liberty case. The second one's a free speech case. And I also want to briefly touch on a free speech case that's coming down the pike that the federal government filed a cert petition on recently called U.S. v. Alvarez. First, let me start with the religion case. Hosanna-Tabor Church v. EEOC is a Supreme Court case about something called the ministerial exception. The ministerial exception is a doctrine that says to federal courts that they should not weigh in on employment disputes between churches and their ministers. So the priest thinks the bishop fired him for a bad reason. Generally speaking, a court won't go into that, and it will say, look, disputes between the priest and the bishop are church-related disputes. We shouldn't be in the business of picking who's going to be the priest in the parish. For the past 40 years, the lower federal courts, literally every circuit, has applied some form of the ministerial exception. So usually we're used to cases getting to the Supreme Court where there's a circuit split. Here, as to the existence of the doctrine, there's really no split. Every circuit has recognized it. Where the circuits disagree is as to who exactly counts as a minister. And that's the question that's really brought into relief by the Hosanna-Tabor case. So the Hosanna-Tabor case concerns a woman, Cheryl Parrish, who was hired as a teacher in a Lutheran school. And in that Lutheran church, in that Lutheran community, they actually call all of their teachers, or most of their teachers, ministers, and they allow them to take minister exceptions on their federal tax returns. They have to take university-level theology courses in order to qualify for many of these positions. And Ms. Parrish had the job that I would think probably sounds familiar to anyone who's thought about parochial school education, which is she taught grammar school. So on one hand, she did religious stuff. She taught religion for half an hour a day. She led the students in prayer. She took them to worship services. A few times a year, she led the worship services for the school. So she clearly did important religious things within the religious community. But on the other hand, she did a lot of stuff that, for the most part, looks secular. So she taught math, she taught music, she taught English. There's some dispute between the parties as to how much she was supposed to bring religion into those things. But I think at a certain level, it's fair to say you can look at those types of tasks and say, well, that doesn't really feel like minister work, that feels like teacher work. The dispute that happens here is that Ms. Perich goes out on a medical leave, and it turns out that she has narcolepsy. And there's a dispute when she comes back. She wants to be reinstated to her prior teaching position, and she gets into a dispute with the principal, and she threatens to file suit under the Americans with Disabilities Act. The church has a policy that says all of our ministers, and they treat teachers as ministers, they have an internal dispute resolution process, which they consider an important part of their faith. They say it's biblically grounded in some of the letters of St. Paul. And they say, we have an internal dispute resolution process, and people who are not willing to do that are actually unfit to be ministers and teachers of our faith. We don't want people in the position of teaching the children in the school if they don't follow the church's rules. This is one of the church's rules. Therefore, you can't come back. This ends up as a retaliation claim under the Americans with Disabilities Act. The ADA, like most employment statutes, does have some exception for religious groups, in that it says you are allowed to prefer people of your own particular religious group over others. And Title VII, for example, the employment discrimination law that would normally prohibit religious discrimination, allows religious groups to discriminate on the basis of religion. So the bishop's trying to figure out who to hire to be a Catholic priest. Well, he's allowed to say, thanks, I'm only hiring Catholics for that one. That's no big surprise. But the ministerial exception takes it a big jump further, which is it says, not only are religious groups allowed to discriminate based on religion for hiring things like who's going to be the rabbi or the priest or the religion teacher, but the ministerial exception also says, even when the person says, I lost my job for a non-religious reason, right? You fired me because you don't like Hispanics. You fired me because you don't like Italians. You fired me because I have narcolepsy and you're discriminating against my disability. The ministerial exception, the idea is that gives, and the petitioner's claim is that gives the church essentially something of a free pass when it's challenged under those types of employment statutes. At one level, this sounds surprising because I think you can make the fair argument that, well, why should churches have the right to discriminate on the basis of something like disability that isn't sort of at the core of their religion? But the thinking behind the ministerial exception, I think, is ultimately pretty sound, which is to say the question as to whether Ms. Perich is allowed to come back to teach at Hosanna-Tabor really gets at the core issue of whether the religious group has the right to pick and choose who's going to be the teachers of religion to the children in its school. And again, if you think about a claim of discrimination by a priest or a rabbi who is fired, it's always possible that someone will state a secular reason and say, well, I was fired not because of a religious dispute, but for something else. But it is frequently the case that the claim from the religious group will be, well, no, you're saying I'm firing you for this reason. I'm actually firing you because I have a doctrinal disagreement with you, or for a religious reason, I don't think you are fit for the job. What I think is very interesting in this case is that the federal government, in its brief, offers what to me is a very cramped view of the religious liberty argument here. They basically take the position that the only people who qualify to be treated with a ministerial exception are those employees who have solely or exclusively religious obligations. And so they look at Ms. Perich and they say, well, look, fine, you taught religion for 30 minutes a day. Fine, you led prayers and you led some religious services, but you did all this other stuff that isn't minister work. It's just regular teacher work. Therefore, this is not a minister. To me, the problem with that argument is that I think under that argument, the Pope isn't a minister either. In that the Pope administers. He deals with finance. He deals with lands. Anyone who runs any church, I would suggest, doesn't fit the bill of being truly exclusively a religious minister. And so I'd suggest that I don't think that could possibly really be the test. I think the issue is going to come down to whether the court believes this idea that someone who does things that are clearly religious, teaching religion, leading prayer, etc., counts as a minister, even if they do some other stuff too. And I think there's a good argument that she should count as a minister. Second case I want to focus on is Knox v. SEIU. This is a union case out of California. And it's about the ability of a union to deduct money from the paychecks of employees who are not members of that union. So under our labor laws in this country, sometimes we have arrangements where, well, particularly in California, their arrangement is that there is a particular union which represents all of the employees of the state. And the court, through some decisions over the past few decades, has said the union is allowed to deduct money from the paychecks of non-union employees. But that money can only be used for collective bargaining expenses. And the thinking behind that is that if the union isn't allowed to deduct that money, you have a free rider problem, right? People won't sign up to be represented by the union, but then they'll happily accept all the benefits to their employment that they get as free riders on other people's union dues. But the court, in a case called Abood, said what the union cannot do is take money that it forcibly collects from these non-union employees and use it for political things like advertising or supporting candidates and things like that. And obviously, after the court's Citizens United decision from a couple of years ago, as we get into the 2012 election cycle, the ability of unions to participate publicly in elections and to raise money and spend it is going to be a big issue. What happens in the Knox case is that the union collects the money as they normally do, and they provide the required notice to people to let them opt out and say, I don't want to pay for the political stuff. But then a month later, they announce that they're going to have a special collection for what they term their political fight back fund. And that is another thing that, as I read it, that strikes me as something a law professor would do on an exam. The test is you're not allowed to use it for political stuff. The union went ahead and called it the political fight back fund. I'm sure their lawyers weren't happy when they saw that. The interesting thing, though, is if you look at the way the law usually deals with union objectors under the current law often have to put in money for things, and it only gets sort of shaken out the next year, so that each year is essentially 1 year behind in terms of the allocation, in terms of how much money is being spent on collective bargaining, which is what they are allowed to take from the non-union employees, versus how much is spent on political expenses. Still, I think the case raises real important First Amendment issues, particularly this idea of taking the money from non-union employees specifically for an announced purpose of using it for political purposes, which is what the Supreme Court said you can't. The Ninth Circuit has a decent argument that in the whole scheme of things, this feels a lot like what we are allowed to do anyway, but certainly a lot of the optics of the case really emphasize this idea that there are people who don't want to participate in this stuff, who essentially have the government take money out of their pockets and give it to the union to spend, and are just told, well, don't worry, we'll allocate differently next year. Last case I want to flag, just really briefly, is this case U.S. v. Alvarez. This is a case under something called the Stolen Valor Act, which was passed, I believe, in 2006. It's a law that makes it illegal for someone to falsely claim to have won military honors. And it's a case against someone who's a member of the water board in, the water board in California. So he was a local politician, and he claimed to have won military honors that he had not won. And the question is, can the federal government make it illegal to tell a lie? In particular, this particular lie that you've won you've won military awards. The Ninth Circuit, in my view, got this one right, which is, although it's not speech that we love to protect, generally speaking, the government doesn't have the right to simply declare a category of speech false and say, we will punish it if you tell that lie. Generally speaking, historically, the only time the government can punish false speech is if it's in a context like fraud, where someone has been defrauded and lost money or something like that, or defamation where it's caused damage. But the idea of the government having the ability to simply declare certain statements to be false and penalize them when uttered in private conversation is a power that historically the government doesn't have. Again, the federal government has petitioned for cert on that one. They've asked the Supreme Court to take it. I think it's entirely likely that the court does take it and does what they've done recently with Westboro Baptist Church and U.S. v. Stevens, which is, I think they sometimes like to take cases with unsavory speakers who are doing things that we generally think, well, that's a bad thing to do, we shouldn't allow it. But in many ways, our free speech doctrine is built entirely on the speech of those unpopular speakers, and if they take it, my prediction would be the court affirms it pretty easily.
All right, thanks very much. I have a quick question, and I think Tom's got a question for you too. But how significant is the Knox case to the unions? I mean, how big a deal potentially is that if they were to lose that case?
If the court rules narrowly, I mean, so the narrow ruling I think the court could give is it would say, look, if you're going to have a new collection, you have to give a new notice and a new chance to object and get out. If they do that, my instinct is it's not a huge deal to the unions. They still would get much of their money. It wouldn't be that big a deal. I think the bigger danger for the unions is that the case brings up what seems like an anomalous thing, right, which is that the government's allowed to take money from certain private people and give it to people they don't want to represent them, and allow them to use it for things they don't want to do. I think any chance of the court getting into that issue and making rules that would further pare it back, I think that's the real danger for the union. Is if I were a lawyer for the union, I wouldn't want the court touching these kinds of cases. I would just want to leave well enough alone.
Yeah, I had a question on the Hosanna-Tabor case. I have seen some suggestions that that the government's position may be an attempt to get the court to cut back on the ministerial exemption on the theory that this is the text of the various statutes doesn't support the breadth of the ministerial exemption, and the ADA in particular hasn't been construed by the Supreme Court to recognize such an exemption beyond the text. Do you think, first of all, do you think that risk is there, and do you think the court is going to be interested in getting into that?
You know, I don't think the federal government makes that argument. I don't think the text of the statutes is all that much in play. I think it's really background, because the church here isn't claiming they have a statutory right. They're claiming they have a constitutional right, and they say under the Free Exercise Clause, under the Establishment Clause, which generally prohibits the government from picking ministers, under their religious association rights under the First Amendment, they're saying they have this right. So they're basically they're giving up the statutory argument. They're not trying it. I mean, I think it's not in the ADA. It's just not there. So they're making the constitutional argument that the idea of an employment litigation lawsuit that could end with an order from the federal government, you need to reinstate person A as your minister, violates the First Amendment in a bunch of ways.
All right, thanks very much, Professor. Now we're going to go down to Mike Carvin, who has the most obscure cases of the term to summarize. So, you know, like if you want to get coffee now. Mike's going to be talking about the healthcare reform individual mandate cases. I'm not sure what order you're going to go in. We all know that one. And then a group of two cases involving potentially the use of race in the admissions process, and then Blumen versus FEC, which campaign contributions by foreign nationals. So take it away, Mr. Carvin.
Thanks. The other thing my cases have in common is that the court hasn't granted cert in any of them. Well, at least with respect to the individual mandate cases. Yeah, they're definitely going to take the individual mandate cases. We know that from what the Justice Department did not do yesterday, which was the dog that didn't bark. They did not seek en banc review in the 11th Circuit case, where I was counsel along with Paul Clement, and since they didn't do that, they're going to take that case. Undoubtedly, they're not going to allow a decision that struck down a federal law, particularly one of this magnitude, to just sit out there. So this will be decided by the court, and because of the timing, it will be decided this term, which was very much in doubt prior to yesterday and what the Justice Department decided to do. For those who don't know, there's three issues in the case of, I think, descending importance. But the first one is whether or not the individual mandate in the Health Care Act is constitutional regulation by Congress under the Commerce Clause or the taxing powers. The government, per Neal and others, argues that the power to regulate commerce encompasses the power to regulate the absence of commerce, to regulate compelling commerce. They can force you to buy health insurance since they can regulate you when you choose to regulate health insurance. And then they also argue that it's a tax because there's a civil penalty attached to your failure to comply with that lawful mandate. The first argument is split the lower courts. The second argument has been singularly unsuccessful in convincing anyone. But obviously, since there's a split in the circuits and since the 11th Circuit case struck down the individual mandate, as I said, this is going to go to the court. The second very closely related issue is whether or not the individual mandate is severable from the rest of this very 2,100-page act. The Justice Department, quite interestingly, said, no, if you do strike down the individual mandate to buy health insurance, you also need to strike down, it is inextricably intertwined with the draconian regulations on the insurance companies to require them to take people with pre-existing conditions, to require them essentially to ignore, for health insurance companies to ignore whether or not their customers are healthy or not. And they're inextricably intertwined because that will obviously drive up health insurance premiums dramatically. Those restrictions and the purpose of the individual mandate was to drive them down. The 11th Circuit, interestingly enough, though, took a more conservative view, I guess you would, than the government itself. It said, no, even the insurance provisions that are inextricably intertwined with the individual mandate can be severed from our decision to strike down the individual mandate, so they upheld the rest of the Act except for the individual mandate. The final issue, which has just emerged very recently in a Fourth Circuit decision, is whether or not all of these challenges to the individual mandate are impermissible under the Anti-Injunction Act, which enjoins the government from, which prohibits federal courts from enjoining challenges brought for the purpose of challenging the collection of a tax. And again, the government conceded that the Anti-Injunction Act did not apply in these circumstances, but the Fourth Circuit nonetheless went ahead and said that it did. So there will be a decision up there. I think the only question is whether there'll be one or two or three. The way I'm biased because I'm involved in the 11th Circuit case, so I'll get that out on the table. But the 11th Circuit case involves the NFIB. Standing there is uncontested. It also involves 26 states, attorneys general represented by Paul Clement. Since, again, the act was struck down, the government will presumably petition to say, take this case. And I think very likely that they will take that case because, again, it doesn't have any vehicle problems. The other interesting issue is whether or not they will take some of the other cases. There's a case out of the Sixth Circuit called Liberty University where the government's response, I think, is due this week. There they've got some vehicle issues because standing is contested and they didn't brief or argue below this whole severability question, so it doesn't bring a whole lot to the table that the 11th Circuit case doesn't otherwise bring. The Fourth Circuit case never reached the merits of the constitutionality or of severability because, I say, they went off on this Anti-Injunction Act issue, which, A, doesn't seem to be particularly persuasive, but more important, it's really present in every case because if it is jurisdictional, then the fact that it wasn't decided below doesn't matter because you could decide it in the 11th Circuit case. And if it is jurisdictional, I'm sorry, if it's not jurisdictional, then the government has waived it because they have not only not argued it, they've affirmatively disavowed the notion that the Anti-Injunction Act is present. So this is all sort of inside baseball, but I think it is interesting to figure out whether or not the court's going to have a number of vehicles to discuss all these things. I think we'll know much more very soon from the government in terms of when this is all going to be teed up. Obviously, the issue itself has tremendous impact in terms of the law, in terms of the scope of the Congress of Power and the Commerce Clause. The severability issue has tremendous economic and political impact because all of these other issues involving these huge Medicaid payments, all these insurance regulations, all these taxes will rise or fall in terms of how that severability issue is decided. And there will also be, of course, the political question where cynics were thinking that the Justice Department might try and slow roll this to push the whole resolution of this issue past the next presidential election, which would have happened if it had been pushed to next term. But for whatever reason, they've plunged ahead, and it looks like this will be decided sometime in the summer before the election or the late spring before the election, so it might well be involved in the political campaign as well. So I think we all know about those cases. I think we all understand their import. I'd be happy to chat further. There is this other case that I did want to bring to your attention, this Blumen against FEC. Again, I'm counsel of record in it, so you can figure out why I'm trying to bring it to your attention. But well, there's two things. One of it is they haven't granted the case, but it is a direct appeal from a three-judge court as opposed to a cert petition, which means the court has to decide the merits. Now, they can decide in the summary affirmance, which I think is highly unlikely in these circumstances because it is a unique and novel constitutional issue. So I do think that they will resolve the case. It's an interesting case, and certainly has media attention, particularly it seems like post-Citizens United, the press is following very carefully how all of these campaign finance cases are decided. And it also has the potential for interesting coalition of votes, which when I explain the issue, I think you'll see why. The issue is essentially federal law says that people who are not citizens or permanent resident aliens, those who are on a citizenship track, can't give any money, can't give a penny for a contribution in a local, state, or federal election, can't expend any money to say that they endorse a candidate or at a local, state, or federal election, and can't even give any money to groups like Club for Growth that are tax-exempt organizations, advocacy institutions, if those organizations spend part of their money advocating the defeat or election of federal candidates. So it's an extraordinarily sweeping prohibition. It would obviously be unconstitutional if it applied to citizens. So the question is whether or not this class of people, these people are not, they're living in the United States, they're not yet permanent resident aliens, but they are here on various exemptions for 2 to 5 years. They all pay taxes, they work in law firms, they work, one of them is a doctor, whether or not they can be completely barred under the First Amendment from making these contributions. So on the one hand, the interesting point is, like Brett Kavanaugh wrote the opinion saying that this was constitutional for the 3-judge court that's now on appeal, and that reflects sort of that the, quote, conservative wing of the court tend to be very aggressive in terms of the First Amendment rights of people to engage in campaign finance activities. On the other hand, you could argue they've been more conservative about extending full citizenship rights or full constitutional rights to non-citizens. I think it's relatively clear about both a matter of history and about a matter of case law that the First Amendment does apply to people who are resident aliens who are not citizens. We make the point that the word citizens is not in the First Amendment. It doesn't even apply to persons. It says that Congress shall not abridge the freedom of speech, and that the court has recognized that that people who are not completely within the constitutional compact nonetheless are protected in these basic speech rights. And I think Judge Kavanaugh took a relatively different view, and he focused on a bunch of cases where under the Equal Protection Clause you could exclude resident aliens from working in government. And he says if you can exclude them from voting, if you can exclude them from working in government, then you should be able to exclude them from talking politics. And we said that was an inversion of Justice Holmes' famous aphorism where he said when the right privilege distinction was available that you have a right to talk politics, but you don't have a right to be a policeman. That's now a discredited view, but Judge Kavanaugh was saying if you don't have a right to be a policeman, you don't have a right to talk politics, and we don't think that makes a whole lot of sense. We think the people who are making the decision on who will be their elected leaders or who will be the people enacting the laws are the citizens, and you can't exclude them from hearing relevant voices because you think they're going to misuse that information or that the voices might be suspect or you may suspect their motives. So I think it has enormous implications, first of all, for I think the logic of Judge Kavanaugh's opinion necessarily includes people who are resident aliens, who are here permanently. It also has enormous implications. He purported to apply strict scrutiny, and if this kind of strict scrutiny analysis is applied to other free speech provisions, it will dramatically weaken the protection that strict scrutiny does apply in those circumstances. So that should get teed up relatively soon, and as I say, I think it'll be a fairly interesting argument and a fairly interesting analysis of which justice votes which way. Finally, 2 cases which haven't been granted may or may not get to the court. One is sort of, I'll talk about it quickly, a case out of the Fifth Circuit called Fisher versus University of Texas. And basically this is a revisiting of the Grutter cases from the University of Michigan, where Justice O'Connor essentially said if you're quiet about using quotas and achieving racial balance, then we'll find that it's okay. As long as you use the word diversity and talk about critical mass, we'll allow this to happen. and in what had happened in Texas was they had actually enacted this program where they took the top 10% of all people graduating from Texas high schools, which that alone had a result that they were getting in the University of Texas 20% black and Hispanic admissions every year, which to people not as obsessed with racial balance as the University of Texas, which seemed to be relatively good representation, something approaching critical mass. They wanted to add yet another preference on top of that to achieve greater classroom diversity, to ensure that there was at least 3 minorities in every chemistry class, because that would dramatically affect people's educational opportunities. And in a 7-5 decision, it was first upheld, then 7-5, it was upheld again in the en banc Fifth Circuit. And again, I think the issue here is going to be whether or not they're taking these affirmative action cases seriously at all. I think it's a fair bet, particularly given his vote in Parents Involved, that Justice Alito is not nearly as sympathetic to these racial balancing schemes as was Justice O'Connor. This might be a good case to say that, no, you just can't mouth a lot of platitudes about diversity. You must actually show us some evidence that having 22% admissions is actually going to affect people's educational outcomes as opposed to 20% before we're going to allow you to judge people on the basis of race. Whether or not this is the precise vehicle they use to cut back on Grutter or actually put some teeth back into the equal protection analysis is not entirely clear to me, but I think there's a fairly decent chance they're going to take that case. Finally, there's a truly insane decision out of the Sixth Circuit, which says, since the 14th Amendment prohibits preferences on the basis of race, it, of course, invalidates a state law which prohibits preferences on the basis of race. That is, the 14th Amendment requires what it barely permits. And since Michigan enacted this initiative that said you really shouldn't judge our citizens on the basis of irrelevant characteristics, essentially echoing the 14th Amendment, the Sixth Circuit, through some reasoning not immediately apparent to the non-legal mind, said, no, that's no good because it cuts out of the political process people who want to advocate preferences, so we're going to strike that down. The good news is it's been taken en banc by the Sixth Circuit, so they may correct their own mistakes. I think there's a couple of recusals by people who you would expect to vote to uphold the Michigan Civil Rights Initiative. So unless the Sixth Circuit clears its own house, I suspect strongly the Supreme Court will do it for them. I'm given certain confidence in that because about 10 years ago, California passed Proposition 209, which did exactly the same thing and said no preferences. That was the case I actually was involved with. And amazingly enough, we won in the Ninth Circuit. Even more amazingly, we survived en banc, and then cert was denied. So I don't think there's much stomach on the court for the notion that the 14th Amendment mandates racial discrimination. We'll wait and see. Thank you.
All right, anyone want to jump in before we go to Mr. Katyal, who I know is going to want to have something to say on Mike's summary?
On Mike's summary, I guess I'm not going to talk about healthcare. It's too complicated because I was heavily involved in it. So maybe I will refrain from comment and just get into FCC versus Fox.
FCC versus Fox.
Unless anyone else wants to say anything.
Anyone? Save your comments?
Because Mike was
Mike is
not
just so
controversial.
overwhelming that he gets the final word.
When you've given such an even-handed presentation, no room for further comment.
All right. So Federal Communications Commission versus Fox Television. This is the inverse of Mike. This is a case that the court has granted. It's another one that I wrote the cert petition in. So I will try and be fair and balanced since this is about Fox. This marks the return of the fleeting expletives to the Supreme Court. You have a number of different television broadcasters on stations that are challenging the FCC's prohibition on indecent broadcasting. And this is a return for this case. 3 years ago, it went up to the Supreme Court and on a statutory question whether or not the FCC's policy complied with the Administrative Procedures Act. And the Supreme Court said it did, but it left open the constitutional questions. It sent back those questions to be evaluated by the Second Circuit on remand. And so here's what the case is about. It's about 3 different three different broadcasts. The first is in 2002, the singer Cher at the Billboard Music Awards uttered what the Solicitor General at the time euphemistically called the F-bomb. Then the second broadcast was the next year at that same awards ceremony when Nicole Richie and Paris Hilton, not wanting to be outdone, uttered that word and then also the S word. And then a third broadcast was of the NYPD Blue, an old television show that some of you may remember, in which the unclothed buttocks of a woman were shown on national television. And the FCC determined that all three of these broadcasts contained indecent material and therefore violated the policy and fined the broadcasts accordingly. So when the case went back down to the Second Circuit for evaluation on the constitutional questions, what the Second Circuit did is it said, well, we could look at this in one of two ways. The first way we could look at it is to say, well, when the FCC as a government actor is prohibiting speech, it's doing so here on the basis of content. It's looking at exactly what that speech is. And in general, when the government evaluates speech restrictions on the basis of content, we, the courts, afford very high scrutiny to that. We're suspect. We don't trust the government in that area. But they said here there's a problem with giving heightened scrutiny to this kind of speech, which is an old Supreme Court decision from 1978 called FCC versus Pacifica, which this is about the comedian George Carlin's dirty word speech, in which the Supreme Court said that the government has wide latitude to regulate broadcasts over the public airwaves, that there was something special about that. And what the Second Circuit said is, look, in this new modern era of millions of television channels and millions of broadcast channels, that rationale doesn't make that much sense anymore, but nonetheless, we are bound by it. It's a Supreme Court holding, so we're not going to get into that. And instead, what the court said is that there's a second thing lurking in the case, which is about vagueness. And it's about the fact that as the Second Circuit saw it, there was no rhyme or reason to which broadcasts were being fined and which ones were not. They pointed out, for example, that sometimes indecent material had been shown in news broadcasts, but that hadn't been triggering any fines, but that the broadcast here had triggered fines, and they thought that was impermissibly vague and therefore unconstitutional. And then the government petitioned for certiorari. They asked the Supreme Court to hear this case on the vagueness question alone. The Supreme Court said, we will hear it on that vagueness question, but they also added an additional question about whether or not the policy complies overall with the First Amendment, which many people read to say the court really wants to think about the Pacifica decision and whether or not the Second Circuit's analysis from 1978, whether the Second Circuit's analysis of this old 1978 decision should be rethought. The court might want to get into those sets of things. So the government's filed its brief on the merits, and it's basically said with respect to vagueness that a decision that actually Justice Kagan argued as the Solicitor General, Holder versus International Humanitarian Law Project, says that when there is a vagueness concern, the only people who can assert the vagueness are people at the periphery of the statute, that for whom it is vague. And here, these broadcasts, like the one, these ones that I told you, are ones that aren't at the kind of outer bounds of whether or not they fall within a fleeting expletive policy or not. They are obviously the kind of things that people would know, that broadcasters would know would trigger the FCC's policy, and therefore, even if there is vagueness somewhere in the statute, these aren't the people that can assert it. And I guess just listening, Mike, to your description of your case about the campaign finance folks, I imagine a similar argument could be made. Judge Kavanaugh said I haven't read the case, but your description was, well, people have a right to vote, and the only American citizens have a right to vote. These foreigners do not have that right to vote. Therefore, the greater power to exclude them from the vote implies a lesser power to bar them from giving campaign contributions. And your answer to that, if I understood it, was to say, well, U.S. citizens have a right to hear what the speech is of these foreigners. But that's really a right about U.S. citizens, and unless your plaintiffs are U.S. citizens, I imagine there could be standing kind of problems or arguments a la the International Humanitarian Law Project case that say that maybe someone else might be able to assert that, but not the particular speakers at issue here, the foreigners. But in any event, that's the case. That's the way that the government has briefed the case. The broadcasters, I don't believe, have filed their brief yet. I think there's a big question about how far they're going to push this Pacifica question and whether or not they want to get into the reevaluation of scarcity of broadcast networks and so on, and whether or not the government's latitude in this area should be re-questioned. So that's it.
All right. Well, first of all, can we all just give a round of applause to our panel? Which, again, is just so incredible, and we're really fortunate to have them all here. I thought what we'd do is take questions from the audience. I have a question, but I will wait and we'll defer to the audience. And if you guys don't have any, then I'll get mine. So you had your hand up right away in the back there. So let's go to the back of the room first.
Question for Professor Gattiel. Is this on? Yeah. Since Boumediene versus Bush, the D.C. Circuit has a lot of cases in the detainee litigation context percolating throughout it, and like the Bahani and the Kiamba cases, and the Supreme Court has indicated a relatively lack of willingness to confront new contexts in the war on terrorism, particularly the state secret privilege cases or other issues relating to the detainee litigation context. So I was wondering if you could probably touch upon why the Supreme Court is not interested in that aspect, particularly refusing to grant cert in the Arar case, or in other cases that the war on terror cases would implicate.
Well, I've been recused from, when I was in the government, from all the Gitmo cases, mercifully recused. It was nice to have a break from that for a while. So I'm not probably the best person to ask on all this, but I have been kind of just reading some of the decisions and so on. I think the D.C. Circuit has done an extraordinary job in a really difficult set of circumstances in which there isn't guidance from Congress, and they're making up the rules, and they're doing a good job at it. But, you know, there's a real kind of deep kind of democratic question here, which is I don't think any of us really want the courts to be making rules on these fundamental questions. And, you know, I understand why the Supreme Court hasn't gotten involved, because the D.C. Circuit, you know, at least one reason may be that the D.C. Circuit has generally gotten things in a pretty good place. But in terms of just democratic process and democratic institutions, it's really, I think, a deep problem that Congress hasn't taken a look at this detention issue and established a legal framework for how to go forward. It really puts an enormous strain on the judges of that court.
Sir, here.
Yes, thank you. I'm James Young. I'm counsel for the petitioners in Knox, so I was delighted to see it appear on the list of cases to be dealt with. One of the issues that's raised in the case, and I thought it was a good summary, Professor Renzi, but it seems to me that the broader question of the standard of review was squarely presented in the Court of Appeals, and may be the larger reason why the Supreme Court granted certiorari in the case, and it was two questions. What is your, you seem to think that it'll be determined on narrow grounds. Do you think there's a possibility in your crystal ball that they'll deal with the larger issue?
Professor, just to also remind everyone, this is the union.
Sure,
in this case.
This is a union case. No, I don't have a particularly good crystal ball about this one, so I don't mean to suggest that I do. I would say I think it's entirely possible that they take on the standard of review question. As you said, it was a clear split between the majority and the dissent in the Ninth Circuit as to whether this is some sort of balancing test or you do strict scrutiny. Again, if I were the unions, I would be afraid of the court taking that question. I would think you would likely have a majority to say, okay, if you're doing forced speech of somebody who doesn't want to be there and somebody who wasn't given notice and a chance to walk away, which is what the court has otherwise said is required when unions are doing these dues collections, I think even if you don't do strict scrutiny for a normal Hudson-type situation, you may well say, okay, but if they gave no notice and they gave no opportunity to back out, that has to really be treated as compelled speech, which the court ordinarily says get strict scrutiny, which obviously is a much stronger standard of review than the Ninth Circuit used. So I do think that's possible, and I think it would make a whole lot of sense, frankly.
Nina?
Mike, I was wondering, there was that famous moment in the State of the Union address when President Obama was castigating the court for Citizens United and said, under this decision, foreigners and foreign countries could influence our elections, and Justice Alito said, not true. He mouthed the words, not true. Does that give you pause about your case?
No, not at all. I mean, yes. Well,
never in doubt.
In the media there will be a potpourri of xenophobia surrounding these issues, and that gives me some concern. But no, look. What they were talking about there was foreigners and foreign corporations. What we're talking about here is we're admitting, as I think Neil alluded to, that people obviously who are foreigners don't have any rights to give campaign money. But there's these people in this limbo, in this gray area, who are not yet American citizens but are paying taxes, assuming a number of the responsibilities of citizenship. And the question is whether or not you can exclude them entirely from the political world. I don't think anything they say about folks like that is going to affect a company with 20% or 80% or whatever test they use foreign ownership in terms of...
If I understand your case correctly, you're saying that it's the right of American citizens to have external voices heard. So what difference does the status of a green card holder or a true foreign corporation make to your argument?
No, that's a misimpression. We're not making any right to hear argument, but it seems to me to be an essential distinction between what Judge Kavanaugh was saying and what we're arguing. He's saying that the Supreme Court has held that non-citizens can't exercise governmental power. They can't vote and they can't serve in certain delicate government tasks. And I'm saying that's terrific. But whether or not you're able to make the ultimate purchase or make the ultimate decision is different from whether you can advise others on how they should make their decisions. And all I'm saying is this analogy proves way too much. There's all kinds of people in the District of Columbia and in Puerto Rico who can't vote for president or Congress, but nonetheless, they are fully entitled to exercise their rights to tell other people who they want to be president. So you can't equate the ability to vote with the ability to speak about how the vote should be exercised. And I'm saying that's because the people who are ultimately exercising the vote need to hear or want to hear your views in the marketplace of ideas. So you need an entirely different rationale for suppressing people commenting on who you should vote for than from voting itself.
But don't some foreign corporations pay U.S. taxes?
They might. And I think there's going to be a difficult issue about separating what's a foreign corporation from a non-foreign corporation, but nothing they say in this case is ultimately going to decide that. And all Justice Stevens and Justice Ginsburg were trying to excite Middle America about when they went into their hysterical dissent in Citizens United was true foreign corporations, these zealots of Canadian and Israeli corporations shanghaiing the American political process. But whatever you think about foreigners exercising influence over American elections, again, whether or not people who are here and pay taxes can exercise that right is an entirely different question. At a minimum, you could eliminate all these concerns you have through disclaimers and saying this advocacy of Barack Obama was by somebody who's not an American citizen. There's this case where they got to label political propaganda coming in from Canada, and the court upheld it on the grounds that all they're doing is labeling it, they're not suppressing it, so it's a less restrictive alternative.
Mike, could a community say it wouldn't allow, say at a public hearing on a zoning dispute, that it's only going to allow U.S. citizens to testify, no foreign nationals who may live next to a landfill can express their views?
That's my basic point, right? That there's a big distinction between allowing open access to the marketplace of ideas, and if you want to attach a grain of salt to people who are not in your political community, go ahead and do it. That's entirely different from saying you can exclude them at all from the marketplace of ideas. And the point that may have created some confusion, I was just saying Judge Kavanaugh is mistaken in thinking, because again, that you can't be a policeman, that means you can't talk politics. You don't have any right to be a policeman. You do have a right to talk politics, so that doesn't begin to answer the question. One of the problems with this law, by the way, is, as always, it's way over-inclusive and under-inclusive. It tells people that they can't spend money in local elections. I don't know what business that is of the federal government in the first place, but this may come as a surprise. There's cities in Maryland where people who are non-citizens can vote in local elections. So you can actually vote in the local election, but you can't spend any money telling people who you'd like to endorse in those. So it's actually got the reverse. Plus which, to get to your example, Jan, they allow foreigners or non-resident aliens to get involved in all kinds of ballot initiatives, which directly make law that govern American citizens, but for some reason they don't allow it for candidates. So if you want to dig into the particulars of the law, it doesn't make any sense at any level, and certainly not enough to survive the strict scrutiny that even the three-judge court in the District of Columbia admitted was the applicable constitutional standard.
Ilya.
Ilya Shapiro from the Cato Institute, and I'm going to ask about a couple of questions that have been raised. Maybe of the 7 of you, someone has heard about these cases about plea bargaining, which is a rare feature of the Supreme Court's docket. I think one is Loeffler, the other is Fry. And these are cases where one, the lawyer didn't tell his client, the criminal defendant, about a particular plea bargain. The other one, he advised him poorly on it, to his detriment at trial in both cases. And there's really it's not my area of expertise, but it seems like there's a dearth of law on this. And I don't know whether the court just wants to create law finally to give guidance about ineffective assistance claims with regards to plea bargaining, or they just think that what happened in these particular cases happens a lot and is wrong. But if anyone has views on those cases, I would love to hear them.
There's also an interesting eyewitness case, too. Do any of our Fourth Amendment panelists want to take that on, or any of the crim pro stuff? Anyone? No? Guess not. You know, we didn't.
plead the fifth.
Yeah. I mean, there. But I mean, it does seem, I think this term and what you guys have all seen is this has the potential to be an extremely significant term, especially if they take up Mike's cases, but even if not, and in the area of criminal procedure, some of the cases that we didn't touch on, including that eyewitness identification case, could be very significant. But I think we're going to stick with the cases we have, right? Okay. Any other questions? Yes. You, right there. Sorry. I don't know.
Question for Mr. Carvin. When and if the Supreme Court decides to grant cert in the Obamacare case or cases as it may be, how do you think the court will rule on the various issues surrounding Obamacare?
I think on the merits it'll be 9-0.
So do I.
You know, because of my years of experience and extraordinary insights in the Supreme Court, I think it might come down to Justice Kennedy's vote. I think that's probably where the smart money is, and you know, you could lose a lot of money making that bet one way or another. So I think it'll be closely contested. I do think that people who do think the individual mandate is constitutional might well have a struggle with the whole host of severability issues, because I do think that's a separate analysis. So it's a very tough case to predict, both in terms of the individual mandate and even tougher to figure out how much of the rest of the act it'll affect. In terms of the merits, obviously there's only one side to this debate.
Actually, Mike, I was wondering, do you think that they're going to get hung up on the facial versus as-applied issues that Judge Sutton was worried about in the Sixth Circuit case?
Yeah, I mean, you know, only a Scalia or clerk could mismanage facial versus applied so grotesquely.
And you know, this is Jeffrey Sutton.
He's talking about Judge Sutton.
Yeah, Judge Sutton, yeah. I just, Judge Sutton's theory of facial is you can't constitutionally challenge the requirement that everybody in America buy health insurance because, you know, after all, some people voluntarily buy health insurance. So if Congress passed a law tomorrow requiring everybody to go to Catholic church, you couldn't challenge that on its face because, you know, some people go voluntarily to church. I think he misunderstands what a facial challenge is, which is in no circumstances can Congress require you to buy health insurance, so it is unconstitutional in all of its applications, regardless of whether some people voluntarily do it.
Well, but doesn't that depend on whether you go with this aggregation and inactivity issue? Because I thought that's what he was talking about. He said, you know, if you're going with the theory that, like, Congress cannot regulate economic activity of people who are not engaging in that activity because they haven't bought insurance, they're just not in the market. You know, his point was, well, this challenge would apply to people who have insurance, and the law would make them buy more. So they are in the market, so they're sort of, you know, apples and oranges in this bucket. And, you know, maybe we should slice and dice this a little better. I don't know.
No, that's his argument, and it's no less idiotic rephrased than it was. His argument seemed, yes, that's true. They are regulating people who are inactive in the health insurance market, who have distanced themselves, who are strangers to the commerce. He says, you know, but some people are not strangers to the commerce. Good. Then they don't have to sue. But that doesn't change the fact that applying it in all circumstances to anybody, and the strangers will have standing to challenge it. I read that thing 4 times. I couldn't figure out what he was talking about. So,
Professor, and on the severability issue, doesn't the accounting board decision from a couple years ago kind of give you pause because there wasn't a severability provision, and the court said, well, we'll just read it into the statutory framework even though it's not in there?
Well, that was my case too, and so no, it was your case. You didn't know. Look, they were right if you accepted their premises on the appointments clause that these people were properly appointed. So no, that was a relatively straightforward, vanilla application of the idea: can this thing function in the manner Congress intended? Well, if any, and I think the government concedes quite rightly that whatever you want to say about the law without the individual mandate, the rest of the act cannot function in any manner that Congress intended. Again, the quid pro quo was we're going to take a lot of unhealthy people for humanitarian reasons, which obviously will drive up in premiums and the costs of insurance companies. And the quid pro quo for that was we're going to conscript a lot of healthy individuals and force them to buy health insurance and drive the costs down. And you even had people saying with a straight face that this would actually bend the cost curve. So if you take out the only mechanism in that act that's going to drive costs down to counteract all of these additional health care costs they've dropped on top of insurers, then literally the act can't work in any rational way. And if you've ripped the guts out of the act, it's Patient Protection Affordable Care Act. If you've taken out the major patient protection provisions and the only provision that requires affordable care, sure, you can still tax tanning salons and toilet paper, which is the other parts of it, but none of it will be focusing, operating in a manner that Congress intended. And if there was ever, I mean, you remember how this came down, right? They couldn't change one paragraph of that act without endangering its passage. So I think you have to view it as an integrated whole where every part matters.
Yes. I was wondering if any of you had any thoughts about the chances or perhaps the propriety of Justice Kagan recusing herself from the Obamacare litigation.
Neil?
No comment.
Yeah.
Okay, Mike.
No, I doubt it. And believe me, there's that old expression, if you're going to shoot at the king, you better kill him. So I don't know that anybody's going to actually ask for recusal unless they're pretty confident that it would occur.
Are you?
I view it as a non-issue myself, but
Yeah, so
I can't say I haven't explored it though, really.
All right, I have a question. Yay, I get to ask mine. On the race cases, Mike, do you think the court, and when you think about the Chief Justice's in that Seattle Schools case,
right.
I mean, do you think that the court is ready to take this back up and take another look at
I think that's the key issue, right? I think you've got 5 votes. You've got 4 votes that are solidly against racial preferences. You saw Justice Kennedy's concurrence and the parents involved in other cases, and I think he tolerates racial conscious activities, but he's very concerned about, preferring one person over another on the basis of race. So I think ultimately we're going to get to a state of a constitutional law that's better than you saw reflected in the Grutter opinion. tactically whether the court's going to take this particular case to make that point, or take a case that's not so directly on point with Grutter, make the point and then come back to it. That to me is the interesting question. I don't really know how they're going to do it. Yeah.
Anyone else? Anyone want to weigh in on the panel? No? Well, let me again say thank you guys, all the panelists. And thanks very much to the Federalist Society for bringing them all together so we were able to get all these insights today. And of course, thank you guys all for coming. Thanks very much.